This week on Rochelle's Daily Wire Video Edition, I'm going to crawl way out on a limb and predict that the U.S. Supreme Court is going to grant certiorari to resolve a split of circuits in a case called Rose versus Select Portfolio Servicing. Not only that, in a few minutes, I'm also going to predict how the Supreme Court is going to decide the case. But first, the question is, what is the Rose case all about? Well, it deals with Section 362C of the Bankruptcy Code, which was one of those bizarre provisions that Congress adopted back with BAP-CIPA in 25. It was intended to forestall debtors who repeatedly file bankruptcy to stop foreclosures of their homes or evictions from their houses. But the courts have not been decided what it means. The section provides that to some extent or another, 30 days after a repeat bankruptcy filing, the automatic stay terminates. First, we had the First Circuit hold that the stay automatically terminates as to everything. That is, it ends as to property of the debtor and property of the estate. Then late last year, there was a circuit split created when the Fifth Circuit held that no, the stay only terminates as to property of the debtor. Now, admittedly, the decision from the Fifth Circuit meant that this great reform back with BAP-CIPA was frankly of little value to secured creditors because somebody's home is always property of the estate, at least until it's abandoned or the stay is terminated. And in that situation, the secured creditor is not automatically permitted to foreclose in the Fifth Circuit 30 days after the repeat filing. But a very bright young lawyer who served as counsel for, I shouldn't say counsel, as a law clerk for Supreme Court Justice Anthony Kennedy, filed a certiorari petition, and that petition is probably going to be considered by the Supreme Court, I would guess, at the long conference at the end of September. This cert petition, very well drafted, points out that there is a very important split of circuits on a very important issue of bankruptcy law, because it really has to do with the extent to which an automatic stay terminates 30 days after bankruptcy. Well, interestingly enough, bankruptcy judge Christopher Klein wrote a very comprehensive opinion, which I write about in my column that appears on ABI's website today. Judge Klein's opinion really pretty much reads like an amicus brief that urges the Supreme Court to grant certiorari, and he also makes a very persuasive argument that the Supreme Court should side with the Fifth Circuit and rule that the automatic stay only ends with respect to property of the debtor, if there is any. And believe me, folks, that is my prediction as well. I think bankruptcy judge Klein from Sacramento, California, got it absolutely right. And I think the Supreme Court is going to write a plain meaning decision and say that the stay only terminates with respect to property of the debtor. As I said, you can read about Judge Klein's case in my column on the ABI website. It also has a link to where I wrote about both the Fifth and the First Circuit opinions. Well, that's what we've got for this week. Next week, I will be back again with something, I hope, as equally interesting, at least for you bankruptcy nerds, regarding something that's happened in the bankruptcy world. Until then, be well, stay safe, stay home, hug your family, or at least Zoom with them, and we'll see what happens same time next week. Good day.